Let me respond to some arguments or misinterpretations of the law cited by Ms. Perry. The Meckling case does not stand for the proposition that public agencies don't have to disclose electronic records. No, it stands for they had to disclose existing records. They happened to be in electronic form. The Meckling court said, as long as you basically give them the information, you don't have to go to that extra step. They're taking the position that Meckling says, well, we don't have to give you electronic records. That is a misreading of the case. The Lewis case, which examines 973-090, yes, it says there are strict compliance requirements, but that is for the act of recording, so that citizens are aware that police, that they're being recorded for evidentiary and due process purposes. It has nothing to do with whether those videos get subsequently disclosed. With respect to her claim that, well, trust us, we really do keep these videos longer than 3 years. The court is supposed to rely upon a representation from some member of the IT department that they are retained when their official policy says they're not, and when in fact when Ms. Vetter went to look at videos that she was promised she would get, they said, oops, our system destroyed them. And so I think that we do have a catch-22 situation here. They bear the burden of proof. They haven't met it. Now, with respect to some of her other comments, not understanding, Tracy asked for far more than what Eric Rachner asked for, and why would they respond to Eric Rachner, not Tracy? Well, it's pretty clear, because Mr. Rachner knew exactly what to ask for. I mean, and no matter how they try to gloss over it, public records requesters, they're between a rock and a hard place. They tend to over-request things because they don't know what they're asking for. And so what usually happens, but didn't happen in this case, is the agency contacts the requester and says, well, gee, what is it that you really want? And it's rather disingenuous for Ms. Perry to argue that it's an unworkable standard for an agency to have to second guess. Under the facts presented here, that's a completely unreasonable argument, because SPD, including Ms. Fran Gray, knew exactly what Tracy Vetter was asking for. Okay, let me just go through a couple of the other things that she said that I think are not supported by the record. Oh, the argument with respect to 973-090, making it a crime to disclose. Oh, that is a bunch of hooey, because the Public Records Act itself has an exemption for the good faith release of public records. And it protects anybody who discloses a public record in good faith. The emphasis on 973-0802 is on who wrongfully discloses. It is not wrongful for a public agency to respond to a public records request. And again, I refer back to the statutory and case law authority that if there is a conflict between the statute and the Public Records Act, the Public Records Act trumps. Furthermore, there are no, they claim that they are providing the most narrow construction whatsoever. Well, under their construction, approximately 100,000 videos basically will not be subject to any sort of examination. And the reason why it's important that they be subject to examination is because how are you going to find out if officers are basically violating the badge without basically looking at the videos? It's easy if you happen to know officer so-and-so did such and such. But if you don't know what officer did such and such, but the camera doesn't lie and it captures this misconduct, that's what the public has the right to see. That's why these videos are so important to public accountability here. And it's highly ironic that Ms. Perry uses as an example SPD's wrongful disclosure of an in-car video to the employer of a man who they went in, they used this in-car video without his permission or knowledge to get him fired. They should have been subject to prosecution under that statute. That's the type of conduct that should be prohibited, not responding to public records requests. So, Your Honor, we would urge that, step back, look at how they treated Komo in the fall of 2010, and nothing they did subsequent to then, no matter how they mischaracterized it. And I want to also clarify some confusion. Ms. Vetter did not ask for competing databases. She was just trying to get a database. The slide that Ms. Perry relied on here shows they did have some search capability as of the fall of 2010. That was the slide, Robert, if you could, there it is. I mean, they could do it. But did she tell, did Ms. Friend-Gray tell Tracy Vetter that? No.
When you say competing databases, you mean your client wasn't trying to ask for a combination of databases, she was simply trying to ask for specific information?
Right, about the Koban system.
Right.
Because that's all what she was told, is it's a Koban system, I want to see these videos, I want to find out how you keep them. They clearly kept them, and they never told her anything about what Koban said about how easy it was. She didn't know. They treated her shamefully. And I will conclude my remarks. Thank you.
Yes, Your Honor. Responding to what Ms. Endejan said. First of all, Komo wants to reorganize the SPD. They are questioning how different parts of the department work, and they're getting it wrong. For example, on the log sheets, it was Jason Hardy. Jason Hardy went to the right person. The person, if you read the declaration, Bilal Fayabi is the person in the video unit who is the point of contact for requests that have something to do with the videos. Now, he's a former officer. He said, oh yeah, I remember the log sheets. It's not in here, but Jason Hardy has been in the SPD for 12 years. He knows about the log sheets. We have provided adequate evidence that we searched for log sheets. There's nothing to refute that. Secondly, on the statute of limitations, these aren't just disappearing. For example, Eric Rappner's list, the list that Ms. Vetter ultimately got, that shows videos. Now, we have never said that we have every single video, because we don't. We did have the 2008 crashes. Those happened long before we ever got a request from Mr. Rappner or Ms. Vetter. And the records that Ms. Endejan's referring to as not being there, we've repeatedly explained. Those were lost in the crashes. Now it's like a library catalog where it may show that they're there, but until we check, we don't know for sure. We do have a list of all the videos that we lost. Now, Mr. Rappner did know what to ask for, obviously. He had the experience. But so did Tracy Vetter. She didn't change what she really wanted, the thrust of her request, even after she met personally with people from my office, nor did she change it after her IT people met with SPD's IT people. They got the geeks together, we got the geeks together, and they discussed it. And then this is incredibly revealing, because Ms. Vetter comes in on May 2nd, starts looking at the first installment. 8 days later, she sends an email saying, you know, these methods aren't particularly efficient. Well, yeah, Your Honor, that's what we were trying to say all along, but setting that aside, she says, I've learned a lot about how the system works and found that there are lots of videos that were retained that we have no interest in whatsoever. She essentially withdraws her request and says, we're going to take another. We're going to narrow the focus. Now I'm going to ask for it by badge numbers during a date range. Well, that's what we asked her to do all along, and she didn't do it. The problem was not that SPD wasn't trying to provide records, it was we were trying to provide the records she wanted, and that she didn't change her position.
All right.
Just a few more points. First of all, the good faith release section in RCW 4256, that doesn't necessarily protect somebody from the criminal liability that's in the Privacy Act. They may not be liable for an action brought by an individual for invasion of privacy, for example. They inadvertently put something out. This is a completely different statute. This is a criminal statute. There's no protection under the good faith exemption or safe harbor. And if you look at the statute, it says itself that we can't give them out wrongfully disclosing any recording in violation of RCW 973-0901C. That's the language that says until final disposition. You can harmonize these statutes. It's very common to harmonize two statutes. There are any number of statutes where the courts have looked at them, or else it's just plain on their face that you can harmonize the two. There are many statutes that provide greater protections than the PRA does. They provide for confidentiality, for example. They provide for limited release to certain individuals, just like this statute does. All this says is to the public. It's like your mental health records or your medical records. You can get them. Your lawyer may be able to get them. They may be available in discovery. The general public doesn't get them. This is a temporal restriction, as I explained earlier. There are a lot of temporal restrictions as well. And one misstatement that I would like to clarify. Ms. Endejan keeps saying that in order for something to be withheld under another statute, that it has to be exempt in its entirety forever. That's a misstatement of the law. If you look at the AmeriQuest case, in that case, the court held essentially it was the specific information that was exempt. It wasn't that a record in its entirety necessarily was exempt forever. It was that specific information. The point being that there's more flexibility in this other statute provision than Ms. Endejan argues. Thank you.
Thank you. I want to thank both of you. Because this is an important case, I think it's important to have a written decision. So I anticipate having one no later than 2 weeks from today. Hopefully I'll get it done in 1 week. And we'll let you know if it comes sooner than that. The way I would anticipate doing it is not writing formal findings and conclusions, but simply writing a memorandum decision. If you have any proposed orders, which I see that both of you do.
No, this is mine. I believe that Ms. Endejan submitted hers with her.
Your Honor, yes, I submitted a proposed order when we submitted our initial filing.
All right.
And if you would like supplemental findings, I think we'll wait until you see what you have to say.
All right, thank you.
Thank you, Your Honor.
All right, thank you all.